Yes, welcome to the No State Project here on my YouTube channel, of course. Let's see. There we go. Just wondering what the hell was going on. So we start with the tech issue, but it was a minor one. Actually, I'm gonna. It is November. November. I'm really messing up today. It's August. Should write it down. August 22nd, 2018. Glad to be with you here live from the fortified compound in Mesa, Arizona. It's episode 76 of the No State Project. And I kind of screwed things up because I did not actually get my caller line set up. So I'm going to have to do that while we start talking about certain things. One of the things I want to talk about today, of course, was more activism with the No State Project. So I think we're kind of slacking there. And that's what, we're trying to get to a volunteer society. So it has to do with that, their activism. So I think we need to be doing more of that, even if it's just going to city council meetings and questioning city councilmen or any politician for that matter, and hitting them on the moral issue, being that they are, the way they do business, the way they are supposed to operate is immoral. It's criminal in a lay sense. And because, of course, they gave themselves a free pass. All their crimes are legal, but they're still immoral and wrong, just as if I was to do them, it would be considered obviously wrong. So if it's wrong for me to do it, wrong for you to do it, it's all around wrong for everyone to do it. Again, I did screw up because I do want to just take a moment before we start getting into things. I want to just get connected to the caller line. So, yeah, I know. Okay, that should take care of that right there with the caller line. So I do apologize for that, but we are connected and can do the caller line. So I'm going to actually start doing more stuff with the activism, really helping to focus on not just core procedure helping people, but we do have 4 hours of broadcasting every week of Anarchy Radio here. And so the entire show does not have to be dedicated to just getting things done in court. That's important, but we need to actually start breaking down, the moral facade that they still enjoy. And so we need to be doing that. And I'm happy to take video and post it on my website, or of course through and on my YouTube channel, if someone sends that to me. So go to a city council meeting. Hopefully, yes, there you can, definitely at least get it recorded and confront them on the moral issue. Look, if I was to do things the way you guys do it, and I was to force perfect strangers to give me money, would you consider me to be a criminal? And obviously, whether they answer the question or not, you've made the point in front of everybody. So the point is made that they are operating in a criminal manner. And so what we want to do is we actually, what I want to do anyway, I think to get into a volunteer society, well, one of the big ways in which I think is a very important way to do that is to educate people that it is immoral. And at least if people are going to get elected, let's say with the Free State Project, wouldn't it be pretty radical to move to get rid of all the compulsory taxation? You're still going to have the payments, but they're not going to be compulsory. You're not going to be destroying people's lives. That's a big step in the right direction towards getting to a volunteer society. And it would be pretty damn tough. But imagine someone actually, because that's something you can get into the mainstream media. Imagine someone who is a politician actually putting and trying, working towards getting rid of the compulsory nature of the payment and support. I would imagine that it would bring the moral question front and center on the in a mainstream media where we typically will not be able to get. But somebody who's actually a politician, let's say for the free, member of the Free State Project, not forgetting that nobody helped our friend Bill, but still working towards a resolution, to do that, because I'm obviously not going to get in mainstream media trying to do something like that. But somebody who is a politician and is actually working towards doing something like that, they look, the services, we want the services, we want the roads, we want sanitation, we want water, we want all these things. We just don't want a prison system being the basis for it. Okay, we want to get rid of that particular part, because then all the problems really associated with government, really, in my opinion, I think the data bears this out, is the compulsory nature of the payment. So if you get rid of the compulsory nature of the payment and still keep the services, remember, I've said for 20 years, it's not the service that's necessarily the problem. It's the manner in which it's provided at the barrel of a gun. That's not so good, not so desirable. And before I forget, I do want to thank everyone for the continued support of the big show. I do appreciate it. If you want to help support the show, just go to markstevens.net, hit the sales button, or you can use that, PayPal. But if you want to join me on the big show, it's 218-632-9399. 218-632-9399. The passcode is 2020 with the pound sign. I just saw this Mark talk about Bao. Bao has been on the show. We've spoken about Bao. I'm pretty certain I sent somebody a habeas corpus, but nobody followed up with me on that. And not everybody uses their name, on an email. So it's very difficult for me to go back through hundreds and hundreds of emails to try to find it. They have to get back to me. And so as far as I know, he's still in jail. And I believe that maybe it was Cheryl Hardy that had put him. Well, maybe I can't say. I don't know if it was the monster Cheryl Hardy again or not. But it brings up, there was somebody else that seems to be just as bad as Cheryl Hardy or whoever put Bao into jail. And I believe he's been there for about 6-7 weeks now. If you're listening, if you're familiar with Bao, if you want to get a habeas corpus through, as far as I know, he's not going through a lawyer. So either somebody can get it to him somehow, you can mail it to him, or you can do it on your own, at least until they set a habeas hearing, and then and then Bao can take over. Hopefully, he's just going to stick to the facts and showing that the prosecution has no evidence to support the claim that the court has any personal jurisdiction over Bao, and he'll just stick to that if he has the opportunity. But if someone's out there, you want to do that, you can contact me at markstevens.net, and I'm on the Skype still at Frank Rizzo 3, so you can Skype me. And if you want to do a habeas corpus, I'm happy to work with someone. Bastard Chris is saying he does have an attorney. If he's got an attorney, then my hands are tied. Your hands are tied. You could do a habeas corpus, but they may not accept it. Probably, most likely, they're not going to accept it because they're going to say he has a lawyer. So they may not allow you to maintain that. That really sucks. So somebody has to get through to his lawyer. That's the thing. If it's the same damn lawyer as before, he didn't even object when the judge on her own, Cheryl Hardy, determined that he had to go to jail for a psych evaluation. Not just have a psych evaluation order, but he had to go to jail in order to do that. So really, really layering on the tyranny now. Somebody's saying he got steamrolled at his trial. Yes, I didn't know he was even he had the trial, so I don't have the details. But hopefully we can maybe on Saturday's show get more details and be able to discuss this intelligently. From what I know from somebody in Hopewell, Virginia, there is a lawyer named H. Lee Townsend. H. Lee Townsend III. Yes, he's a judge of the General District Court, City of Emporia County. I guess it's Emporia, but maybe Hopewell sits in that county. But Mr. Townsend has the distinction, the tyranny spotlight. I'll see what I can do about a separate video on this. They probably don't want, I'll just use the word T. for the individual who has had to spend a few hours in jail because with 2 court appearances, he is not allowed to speak at all. He cannot object. He cannot raise a motion. He cannot discuss his motion. He cannot speak, period. So what the judge did this second time this week, put him in jail for a few hours. The jailers told him, the police told him, the only way you're getting out of here is if you promise not to speak. So here you have an individual who's forced into court. And this happens. People will email me, not too often, but more often than I like. And they'll say, I can't speak. The judge is threatening me with contempt. And he even put me in a holding cell for a few hours if I say anything. So what do you do in a situation like that? Well, this guy needs to be outed in front of the city council meeting, or rather it would be, if he's a county judge, the county commissioners need to know about this. And the city of Emporia County, their risk management needs to know that this guy is a bully. There is absolutely no defense for a judge. There's no justification, moral or otherwise, to allow for a judge to not allow you to speak on your own behalf and defend yourself. I'm going to go out on a limb here, and I'm going to say that vocalizing and using your voice when you are physically in court is the main way, the tool that you have to actually defend yourself. You can write motions and you can file briefs and whatnot. You can do that, and you can file objections when you're out of court. But when you're standing in court, I know it's kind of radical. Yes, you're going to have to let somebody speak. He's not being accused of speaking over the judge. The judge won't let him speak at all. So you have to file. So this is what we're going to do. What I would recommend doing in a situation like that, where you've got a judge who's not allowing you to speak, and knowing that you may not have a remedy, even though, well, in practical terms, what I would recommend doing is put in a motion to change the judge. Hopefully you're in a place like Arizona where you can change the judge without cause for just once, and you could just get rid of that scumbag with that. Chances are you're going to have to show, so that have a grounds and show. Well, I would show the grounds even if I didn't have to. You want to put in the grounds that he is a bully, that he's not allowing you to defend yourself at all, that he has actually put you in jail or threatened you with jail for doing nothing more than talking, and you're not interrupting. So you can't actually have a fair trial if you can't defend yourself, and you can't defend yourself if you're muzzled and you're not allowed to speak. So we filed a motion to change the judge. Now, the idea here is that, like I've said before, is to set the stage for a petition for a writ of mandamus to get it out of the trial court. So it's not as tight a knit, a good old boy network. At least we certainly hope so. This is Virginia. So petition for a writ of mandamus is to, a writ of mandamus is an order from a higher court to a lower court to perform a mandatory function of the job. Because it's mandatory for a judge to recuse himself if there is bias that would prevent a fair trial, it's mandatory that they just recuse themselves. And a mandamus, because that's what a mandamus does. If he refuses, then we file a petition for a writ of mandamus. We get into the higher court, and we review the denial of the motion to change judge. And it goes, of course, in front of a different judge. Unfortunately, the motion to change the judge goes to the same tyrant. So in this case, it would go to H. Lee Townsend III, of course. And yes, he's going to tell you about Fongol, and then you file your petition for writ of mandamus into the higher court. And what you want to do, what you have to do, is you will file with that petition a motion to stay the trial court proceedings. This guy is not going to stop. He has proven pretty damn clearly that he is absolutely not going to stop. He has no intention of being fair. And if someone thinks that he's being fair by not allowing him speak, I would love to hear that argument. And again, he wasn't interrupting the judge. That's why I always say never, 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 never interrupt the judge. So if you get the stay proceedings, there's nothing, Mr. Townsend can do until the stay is lifted by the appellate court. And I would say that when they filed a motion to dismiss that, and it is grounds, I don't have the citations off the top of my head, but a writ of mandamus is a proper remedy. And I've at the state level, we've always got them to take jurisdiction. Never at the federal level, because the feds are their corruption is pretty open. But yeah, you get to stay at proceedings. So that's what I would recommend doing there when you got a judge like that. If you're in the court and he says, if you open up your mouth, don't even use the word objection. Just nod and get the hell out of there so you can clean it up on paper later, because it's not worth going to jail. But definitely get to the county commissioner here. This is what I would do, T. Get with the county commissioners. Let them know publicly what this animal is doing. File an initial claim with the risk management. Let them know. If he persists, it's going to, you will file an even larger claim. You will amend the claim, and it'll be a much larger claim to cover the damage that this guy wants to do. I would say file with the Bar Association, but that's not going to go anywhere. It's a complete waste of time. I would say we have a much better chance of getting some remedy by letting the county commissioners know, and then filing with the county's risk management. Again, not letting you speak at all. I think even the most hardened critic for the show would have to say, yeah, that's pretty bad. That's pretty bad. They got to let you speak. So, hey, because the other way that they muzzle you, if they don't want to hear your argument and your challenge, they just force a lawyer on you, like apparently what's happening to Bao. Although, okay, I'm going to assume, I'm speculating here, that Bao did not want the attorney and that it was forced on him. So that's a hell of a way to mute somebody up too. They just force the attorney on you, and I've spoken about that before. So I don't think we need to cover that ground today. So we're going to get to the calls. And the number, if you do want to join me on the big show, it's 218-632-9399, 218-632-9399, or niner. And the passcode is 2020 with the pound sign. So I'm guessing we've got Los Angeles here, or that area. Area code 818. You're live on the No State Project. What's your name? Where you calling from?
Hi, my name's Tim. I'm calling from Texas.
Calling from Texas?
Yes, I was in the trial this week for Bao.
Oh, okay. So we've got
I have a
personal knowledge. Okay, so you can report to us what happened. All right.
Well, no, I have a personal question that I need answered. The Bao stood up. The judge said a jury of 6, and Bao said, I want a jury of 12. And the judge said, nope, you get a jury of 6. Now, in the Constitution, correct me at any time if I'm wrong, 6th or 7th Amendment says matters over $20, you get a trial by jury, but yet in this municipal court, he gets a jury trial. Those are two legally defined terms, and they don't mean the same thing.
You sure about that?
How? Well, I'm pretty sure.
Pretty
a trial
sure.
by jury and a jury trial.
What's the difference?
Well, the trial by jury in the Constitution says 12 and 2 alternates.
It does?
It matters over $20.
It says, well, when you say $20, it sounds like you're talking about the federal Constitution.
Yes, I am.
Okay, are they?
So my question is,
but the thing is, Tim,
ahead.
the issues about a jury trial in the federal Constitution are talking about federal trials. They're not talking about state trials.
So I have different rights in state trials. I don't get a jury of 12.
Well, there are different rights, state rights and federal rights. They're different. So you would have different pretrial rights if you were in the federal court in New York, as opposed to being in the state court in New York. Okay, so there's different pretrial procedures. In both, you have to have Brady. Yes, You still have to have discovery, but the procedure is different. Each state has, where it's supposed to still be consistent with due process, each state can have its own criminal process as long as it is consistent with due process. So there is going to be variations. So tell me, what is the difference between a jury trial and a trial by jury?
Well, a trial by jury is in the Constitution. I get 12 jurors of my peers plus 2 alternates.
Yeah, but let me jump in here a second, because what part of the Constitution says 12 jurors and 2 alternates? What section?
I may be mistaken on that. I believe it's the 6th or 7th Amendment.
But the Sixth Amendment, the federal Constitution, as far as I'm aware, the original Ten Commandments. Go ahead. Listen, the original 10 Amendments. There's no language in there. There's no text that says that there has to be a jury of 12 and 2 alternates. Even if it did, that would apply to the federal courts and not necessarily to the state court, because the state courts can set what they want there. What they can also do is they can give you a 6-member jury or a 12-member jury, depending on what kind of charge it is. Now, obviously, it's a felony, and they want to give you a jury of 6. You got to raise holy hell, and even his lawyer would have been raising holy hell for that. But I don't think he is charged with a felony. It's a misdemeanor. But still, tell me, what is the difference, without citing the federal Constitution, what is the difference, the material difference, if any, between a jury trial and a trial by jury?
Well, in a trial by jury, you get to question each and every one of the, as my understanding, you get to question each and every one of the jurors one by one and strike as many as you need to for cause, whatever, I'm a white male, you're not. Not a jury. That's really not a cause to dismiss somebody as a juror. Well, you dismiss somebody as a juror because they have certain biases that would prevent them from giving a fair disposition. Okay. Well, in Val's case, they gave him a time limit on how long he could question, and that was it.
Sure.
What if he had more questions? What if he had to really dig in?
As long as he can show that the questions are relevant, then the judge doesn't have the discretion to limit the voir dire. But you still get you.
He did.
He did. Okay. Well, that's now unfortunately a question for for a post-conviction relief, a motion to set aside the verdict because declare a mistrial, because it is definitely a reversible error to deny effective voir dire. But as far as the issue being the difference between a trial by jury and a jury trial, I think it's just a matter of verbiage, and I think it means the same thing. It's like people coming in and saying that the Constitution for the United States is completely different than the Constitution of the United States, and I've not seen any actual evidence to that. And here, I've seen them phrase it as a jury trial, and I've watched them do a voir dire. I've seen that in federal court, and it was a jury trial. So I don't. So is there anything else? Because the voir dire is not a material difference, because you get that with both. So is there anything else that you're aware of that?
How do we get from 12 jurors to 6? What is the evidence that ties me into a court where there's 6 jurors? Because look, I had a jury trial on a traffic stop, and they gave me 6 jurors.
Right.
One of them was the judge's husband. The other one was the mayor. The other one was a sitting city councilman. And the other one was the judge's next door neighbor.
Are you, and you can prove that? And they actually
not.
Wow. You're telling me that the judge was so brazen as to sit his own wife as a juror against you?
Husband.
Oh, I'll say spouse, esposa, yeah. Wow. And all these other officials.
That's not my question.
It certainly raises questions with me.
What is it that binds me to those proceedings? Because in their rule books, it says that they can do that. According to her, Well, what binds me to that court? Why am I bound to this court? What evidence is there that says that I have a right to somewhere? It says somewhere that I have a right to, federally, to a jury of my peers.
Well, but we're getting this. We'll get back to what binds you to the court. Okay, okay, but I want to still I want to finish the issue here of the 6 or the trial by jury as opposed to a jury trial. Are there any other material differences between a jury trial and a trial by jury?
In my mind, a jury trial by jury trial is what the municipal court, state law, their little club, it's in their law books, whatever says. But I have rights, I thought, under the 6th or 7th Amendment to the trial by jury 12 plus 2 alternates. I may be wrong.
I think you are wrong. And because, again, like I mentioned, the federal Constitution, even if it laid out for federal trials, there has to be 12 jurors and 2 alternates. That doesn't have any application to the state courts, which have historically always been able to set their own court procedures, and as long as they were consistent with due process. Now, a problem would be is if for a criminal charge they said it didn't have to be unanimous vote to convict you. That I think would be reversed, and they wouldn't allow them to do that. But just having 6 as opposed to 12, historically, that's not. I've never seen where the Supreme Courts have said that that's a due process problem, as long as it is unanimous, and you do have a jury that you're able to voir dire. So you're able. So maybe what we could do, just to move on in the interest of time, there is no material difference between a trial by jury and a jury trial. It's just a matter of words. There's no material difference. And
so I was bound to that court where the judge can put her friends and family member, and I was bound to that then.
Well, I'll get to what binds you to the court in just a second. I cannot let go of this. The list of people that were on this so-called jury of yours, that is without a doubt one of the worst cases of stacking a jury I've heard since the Reconstruction. Wow. Did you get a chance to voir dire these people like Bao did? And is that how you found out who they were? I mean, how did you? All right, so let's just ask that question first. How did you know who these people were? And did you object to them?
The judge told me. The judge told me after the fact.
Wow. And did you object?
Well, it was a year after. It's been a year ago. A year after I was in for another violation, which I just paid because you can't win against the judge's husband.
Well, there's no doubt there, but obviously you've got grounds for to reverse that, because the judge sat friends and family. You're talking about, technically that's a felony. That's obstruction to knowingly seat. And the prosecutor had to know that the mayor was on the jury. The prosecutor had to know. They had to know who the mayor was. That's insane. All right. We'll have to.
Welcome to East Texas. That's all I can say.
East Texas. That is. I actually witnessed a federal judge who was called in as a ringer, who was threatening a defendant not to raise certain issues or he's going to go to jail. Even he realized that there were too many government employees on the jury, and he continued picking the jury. It was too many. Here, a spouse is on the jury, and the mayor and other government. Wow, I'm going to have to get with you after the show, and you're going to have to give me these details, because this is something I want to investigate. So let's move to what binds you to the court. There's no actual evidence that binds you to that. It is a threat of violence.
She said that was completely legal. Okay, so where is the evidence that binds? If I go in front of another court like that with 6, I'm going to say what binds me to these proceedings, because I know how corrupt these courts are.
Yeah. Well, you should be doing that already. I mean, that's something that Bao should have been doing weeks before something like this happened. You're always the main argument that the prosecution has, the foundation, is that the laws apply because you're physically in Texas. That's it. Everything flows from that. That's the foundation, and that's why we jackhammer that thing to death. That's why our focus is almost 100% on the prosecutor's claim of jurisdiction, and that goes to subject matter jurisdiction. It's also an element of the charge, because without the code, there is no crime because it's mala prohibita. So there's no evidence that binds you to it. You should be already have gone through and brought out in a motion to dismiss that the prosecution doesn't have the evidence. If they deny the motion, they want you to plea, then you say you intend on pleading guilty. Has the prosecution submitted sufficient facts to prove that just because I'm physically in Texas, the laws apply? And so then you're doing that through pretrial, because in pretrial, you want to know also the name of the witness with personal knowledge of the matters he's testifying to, namely the laws apply to you and you violated them. Now, does he have personal knowledge of those two issues, those two things? Of course, he has no personal knowledge of the first part, which means that everything he says about the second part is completely irrelevant and not admissible. So this is something that should have been brought up every single appearance that you were at before getting to the jury.
Okay.
So,
well, I brought that up and it was overruled.
Okay.
And, I mean, it was just a circus court,
Well, but we have other remedies.
Don't want to hear about I'm sure people don't want to hear about a year-old case. I do have something to give you an update on Bell's case.
Okay.
What I observed. The actual objections that he made, majority of them were overturned, and very few of them was sustained. And the other way around, the prosecutor, his objections were sustained, and very few of them were overruled.
I'm surprised that anyone. Can you give me an example of an objection that the prosecutor made that was overruled?
Not off the top of my head, but I can tell you that the ones that Bao were sustained was what he said, leading the witness.
Okay.
And that was the 3 big ones that he put out that, my vision of going to court is you've got a prosecutor and a judge and, some bailiffs, plenty of bailiffs. But I didn't expect them to be 2 prosecutors and someone sitting behind the prosecutor giving them information, and a team of 12 attorneys that were in the courtroom the entire time. And they took turns taking notes. They were there for the examination of the
police officer?
No, the jurors, and they were taking notes.
Okay.
And they were there the entire time of the trial, and it felt like it was Bao by himself with no access to computers and spreadsheets and printouts and laser overhead projectors that the prosecution used. Bao was there with pen and paper, and that was it.
I thought he had an attorney.
The tools he had. He didn't have the internet. He didn't have all the resources. He didn't have 12 research attorneys behind him.
He didn't need it.
That's what the prosecutor had, was 12 research attorneys behind him.
Well, the thing is, though, Tim, that you don't need that, because the fact is there's no chance in the world that the prosecution can make their case. They cannot prove that the laws apply and you violate it. It's impossible. They cannot do it. They do not have a witness with personal knowledge of that. They don't. It's impossible. We don't need to have these teams. We don't need to have the internet while we're. It's nice to have that if we can somehow broadcast it so other people can hear it. We don't need that. I'm getting lined up with calls, so I want to move through this quick. We may have to have you call with a better report, a more accurate, a more comprehensive report on Saturday. Wasn't there an attorney that was? He didn't. Someone mentioned that he was working. He had an attorney.
It was Val by himself.
Oh, somebody mentioned he had a lawyer, so that would not be good for a habeas corpus. Oh, okay.
And the observation that I made is he never once got upset. He never got angry. He held his composure 100% of the time. Other than the 3 times I caught Val smiling at one of the cult members. That's what the prosecution called his following, cult members.
Oh my gosh, they got away with that? Did he object to that? Wow, cult members. Well, I hope he objected to that, because that is insanely prejudicial. He did not. That, for everyone listening, when they call you a tax cheat, when they say you're a sovereign citizen, when we're anarchists, when they say that people who watch you on or know you are cult members, you gotta object. That is insanely prejudicial. So hopefully he didn't object. So how does he raise the issue on appeal? Oh my gosh. And that is incredibly prejudicial. Well, all right. The last thing I want to discuss, which is really important, I want to know how he did on the cross-examination with the police officer. Did he ask the police officer the facts he relied on to prove his claim that just because Bao was in Texas, the laws applied?
He did not ask that question specifically. He did start to go down that road, and the judge snapped at him.
Okay.
And would not allow him. I mean, I couldn't have got past that judge. I mean, I don't have the skills that, some other people have with verbal skills to get there. And no, he did not ask that specific question.
Okay.
And that should have been the question right there.
Yes. Now,
because I asked that. I asked that in my trial.
Okay.
And the prosecution stood up and objected and said he wasn't qualified, just like your work shows. And I stood up and I said, I want to have it dismissed, just like you. I had it written down. I expected it. And she said overturned.
Overruled. Okay.
Overruled. Right.
Right. Did you get any dialogue and ask him?
I'm well aware of the line. He did not ask that question specifically. No.
Because he was stopped by, like what they did with so many other people. They stopped him and would not permit him to do that. Well, certainly for a post-conviction relief, you got a denial of cross-examination. And I would recommend I would do that. Before I let you go, I would say when we're in that situation again, Tim, or anyone listening, and they say the witness is not qualified, excuse me, I need you to be very clear. He's not qualified to determine the laws apply to me and I violated them. Is that what you're ruling here now? Be very clear, sir. Because if he's ruling that he's not qualified to determine that you violated the law, that throws his complaint right out the window. He wasn't qualified to make those statements on the certifications on the complaint. If he wasn't qualified to make those statements, they got to strike it. And yes, for goodness sakes, before the trolls come in, yes, you can strike a charging instrument. Absolutely, you can charge or quash a charging instrument. So definitely, when something like that happens, you want to get a clarification. He may not answer it, but you want to clarify. You want to try anyway, Tim and everyone else. Are you saying that this witness is not qualified to testify that that the laws apply and I violated them? Very important to get that in. So see if you can give us a call on Saturday so we get a better idea what happened with Bao. Okay.
All right, man. Hey, enjoy your show, man. Keep it up.
I appreciate it, Tim in Texas. And I would recommend anyone who's got contact with Bao, the denial of voir dire and denial of cross-examination are two huge errors. And if he has to appeal because they deny post-conviction relief, if he can't prevail on that, You got no chance. If we can't prevail on a blatant denial of cross-examination, then there's your evidence of a rigged game. You never had a chance to begin with. So want to get to, wow, holy crap. Let's get to other callers. We've got Ben in Colorado. Ben, welcome back to the show. You have good news today?
Yes, I had my case about a week ago.
Okay.
And yeah, pretty much didn't get to do anything. The judge just quoted me saying, I said, my intent is to plead guilty, and it pretty much ended with like, oh yeah, since you intend to, I'm taking your plea, after like 3 or 4 times of back and forth.
Did you say I intend? I didn't actually plea?
Yeah, that's what I said. At the end, I said, let the record reflect that she's entering a plea, and I did not enter it.
So he entered a plea of guilty against you?
Yes.
Wow.
She actually. Yeah.
She. You didn't actually sign anything, did you? You have to sign a plea of guilty.
No, I never signed anything, actually.
So is she ordering you to pay a fine without any signature to a plea of guilty?
Correct. I never signed anything.
But is she forcing you now to pay a fine?
Yes. Well, they gave me a sheet from the clerk, and it had like $200. Had to go pay.
Oh man! Well, hopefully you can. I would file a motion to set it aside because you did not plead guilty. The judge did it. You know, their rules are fairly clear on that. Only the defendant or his attorney can plead guilty. It's not like pleading not guilty because they're lying, saying that you're refusing to plea. Okay, it's different.
Well, that's the thing. It was just me, the judge or the magistrate, and the police officer and the clerks. There was no one else in the courtroom.
I don't know why the hell the cop was there, but all right.
So he was the one prosecuting me, apparently.
Oh, okay, all right.
The city attorney does not prosecute; the cop prosecutes you.
Got it. Okay. Well, I would say file it, and you don't. You know, you can use my template for this. Just cut most of it out, and you could just put in there. It's a motion to set aside the plea and judgment and make it real short. The judge was mistaken. We knew I would. How do I? The judge deliberately, which I can't think of the word, but the judge did not listen to what you were saying. You were intending on pleading guilty if jurisdiction was proven, and then they, of course, were dishonest and said, well, I'll plead not. And you look in their rules too. It should say right in their rules that the judge, only the defendant or his lawyer can plead guilty. It should be a no-brainer. I mean, geez.
I actually asked them, so what if I don't pay the fine? And then they mentioned, well, pretty much nothing happens, but probably eventually they might, cancel your license or something, or put a hold on it or something like that.
Yeah. They could take a tax return, something like that too. I would not let it go. I would immediately file a motion to set aside the plea and the judgment and vacate the judgment on the grounds that the judge cannot plead guilty for you. You did not plead guilty. You were very clear that you were intending on pleading guilty. You just wanted to know if the prosecution had met its burden on jurisdiction.
So I mean, my case does say it's closed. So is that still something that can be done? Or
yeah. How long ago did this happen? A week ago?
A week, on the 14th. Yeah. So last Tuesday.
Yeah, you still have time. Definitely get it in this week. I mean, it's Wednesday already. So get the motion. And again, it'd make it 1 page long. Motion to set aside and vacate the plea and judgment, because you did not enter a plea. The judge did, and the judge has no authority to enter a plea of guilty. And so look up in their silly little rules there that it should be very clear that only the defendant or his lawyer could plead guilty, not the judge. Okay, and that at least If they're not going to do it, then you have no, it would suck, but you'd have to file an appeal. I would definitely file a claim against the city or the county's insurance to get that $200 and change back. I would do that also.
Are there any forms that you have for doing that one?
I do have a template for that, but yours is pretty straightforward. So you could probably use their form. Start off by getting the form off their website, and you can use what's in the motion to vacate and use that as a basis. These are the facts. I said I was intending to plead guilty if the prosecution had met their burden on jurisdiction. The judge, on their own for undisclosed reasons, went and pled guilty for me, as if they were my lawyer. And the rules are very clear. Only the judge may not do that. The judge can only plead not guilty if I refuse to plea, and that's not what happened. I was intending on pleading guilty, and they cut the process short, violated the rules, violated the due process, and entered a plea of guilty over my objection.
Okay, thank you, Mark.
Appreciate it, and stay in touch. So let me know, if I can help more with that insurance claim.
Okay, sounds good.
All right, appreciate the call, Ben in Colorado. What we do to start what you wanted, let's just say it's in Colorado Springs, there in Colorado. Go to the risk management for Colorado Springs, and that'll get you the form to file a claim. And then again, here the facts are: I said I was intending to plead if they met their burden. The judge didn't want to hear this. The judge argued and just mischaracterized what was happening and violated the rules by entering a plea of guilty. And you quote the rules right there. This is a clear violation of your law. This damaged me to the tune of $200 and change, and I want my money back. You do like Jesse Pinkman. I want my money back, bitch. That's kind of what we're doing when we're filing the claim, but we leave that part out. Let's see. We got one last call we can get to. We've got area code 201. You're live on the big show today. What's your name? Where you calling from?
Yeah, just a blind man from New Jersey, Mark.
What was your name? I'm sorry.
The blind man from New Jersey.
Oh my gosh, we have not heard from you in a while. How's it going?
Yeah, I've been listening. The same old. I sent all the paperwork in here, nothing. So I'm not even worrying about it. And whenever they catch up to me, I'm not even calling about myself today. My brother's son is in a little dilemma. He has an apartment he shares with his roommate in another part of New Jersey. So the roommate let his friend come up from Virginia. Friend was up here for about a week. My brother's son answers the door after a week, and the marshals run up in his house. Now, come to find out, his roommate's friend, who my brother's son don't even know, because he's never been to Virginia, he had killed somebody in Virginia. So they came there looking for him. But my son was like, well, I can't come in the house. He didn't know what was going on at first, but they bum rushed in the door, tore his house apart and everything. And they also found a gun in the house. They locked my brother's son up, took him and the guy they was looking for Virginia. They sent him, the guy from Virginia, I guess he's back in Virginia now on a state murder charge.
Wow.
And they charged my brother's son with the firearm, which wasn't even his. They found it under a stove or something, and they charged my brother's son with it and said that he allowed them in the house and that he also admitted that the gun was his. So they had him for possession of a firearm. Now they're charging him federally. And then today, the lawyer called my brother and said that they're charging him under the trigger lock law. And if I'm not mistaken, that's some kind of like you can get extended term after 3 charges of the same kind. My brother's son doesn't have any gun charges, and they're trying to charge him federally with a trigger lock law. They wouldn't give him bail or anything. He's just sitting in there for somebody he didn't even know. And it's federal court, so I don't even want to try to help him because you've already said how the federal they deal. So he got a lawyer. He got one of the best lawyers in New Jersey on this. But I was trying to find out if you knew anything about this trigger lock, this federal trigger lock law. And they said it started in Mississippi, and a couple of states took this law up.
Well, let me look it up.
Okay.
Okay, well, let's see. California enacted a similar law that requires a firearm owner to keep his or her firearm in a locked container or secured in a locking device. So, looking for it looks like it's been around for a long time. Is it definitely where you have to have priors for it?
That's what it said when I looked it up. A definition came up. It said, but it was saying more about drugs when they use it, and that you have to have 3 of the same charges for them, and then they doubled what they was offering. So they were saying he was facing 10 years. Now he could get up to 20 years, I guess, if he don't cop out to this.
Well, you said that you had one of the best lawyers in New Jersey. I mean, if it's not his gun, he wasn't aware of it, and it was, he had no idea the history of this guy, and he doesn't have the priors necessary to charge under that. It seems like if this guy was a decent lawyer, he would have had him out already.
Yeah. Well, they just got the lawyer for him, and now he is aware about it. But listen, lawyers is part of the system too. So I know they all work together at their little club, and I just don't trust nothing they say either. And I already know, dealing and listening to you, how they all down with each other, and they don't fight jurisdiction or anything else. But yeah, it should be an open and closed case, because first of all, they had no search warrant. They might have had a body warrant. I'm not sure. He said he asked them for a warrant, search warrant, anything. And they said, man, we ain't trying to hear you. And they just went up in his house, knocked holes in the walls, all kind of crazy stuff. But you're in there looking for a murder. You're there for a certain person. He said that they had him already. And then they wrote in the report that they was doing a protective search. So they started searching the house. That's how they wrote it down in the report. I'm saying with a good lawyer, like, he should be able to beat this, because there's no search warrant. There's a body warrant only. They got the person they was looking for. After they had him, I figured they were supposed to leave. And I'm like, well, they shouldn't even search the house. But they're trying to say it was for their protection. So they, went through the whole house, knocking things in. And they did get him a good lawyer now, and I'm pretty sure. But I just wanted to know if you knew anything about that trigger lock law, because I know for sure, the way I'm reading it, it does say the three same charges. But these people change things up, and they do what they want.
Well, and they want a conviction. They want a conviction. So they feel that he's got a lawyer, and the lawyer may just want to make a deal and not want to actually fight this. If that's going to be, you have to find out if the lawyer is willing to fight it on, and get it thrown out. Because apparently, from what you're telling me, and I haven't investigated it, from what you're telling me, it seems like it's a slam dunk that even if the federal judge is not willing to do the right thing, talk about misconduct. At least with the lawyer, you might be able to get something into the higher court to quash the indictment. I mean, it sounds just. Well, let me ask you: do you know that he's been indicted, or has he just been arrested for it?
The lawyer we hired, they hired him Friday. He just got all the paperwork, and I guess talked to the prosecutors and everything. And he said that they upped his charges from the possession of the firearm, and now they're going to charge him with the federal trigger lock law. And he needed another additional $5,000 for him to fight it, because it's going to cost more. They already paid him $5,000.
Well, he's got to do something for that $5,000.
This happened Friday, as far as paying the lawyer.
Okay, well, the $5,000 should cover at least some initial motions to quash and find, because he may not have been indicted yet. It seems wow that that's the thing. They can't indict a cop for shooting a white cop from shooting a black guy running away on video. They can't indict then, but but they here with all these problems, they can get an indictment. I was like, oh, is the perp black? Oh, indict. All right. Well, I would need more information, find out if he's been indicted, and I would certainly be letting this lawyer know that we'll be happy to take our $5,000 somewhere else if you're not willing to get him totally off of this, because this is not it seems pretty clear cut that well, it's not one of these, oh, they're going to throw the book at him. They already are, but none of it should really stick from what you're telling me. So find out if this lawyer's willing to do the right thing.
Okay, so I just wanted to give you a call, just to ask if you knew about that law, and I wish he could use. I've been trying, show people, man, like get into this, man, learn about this, because you never know what will come up. And I also remember you was like you got barely no chance with the feds. Well, using your approach.
If it's the IRS, you don't have a chance. If you're in a tax situation, you have one chance in 12 in getting a hung jury. If the IRS files, if it's not criminal and the IRS files a petition to enforce an IRS summons, you will lose. There's a 100% chance you cannot beat the IRS on a summons charge. You cannot do it. Not even worth trying. You're not. But that's for another show. We're about out of time. Find out what the lawyer's willing to do and let me know.
Okay, no problem, Mark. And thanks for the help and keep doing the great job you're doing.
Appreciate it. It's our friend of the show. He's been on a number of times, calling from New Jersey. And I'll have to look into that. From what it says here, all I found just trying to, while I'm doing the show, is it's not telling me about the three priors, but something is, these prosecutors, boy, easy convictions, people who aren't going to necessarily fight, or they're going to hire a lawyer who's just not going to put up a fight at all. That's right. He's going to need an additional $5,000. He was just hired on Friday. What could he have? How much could he have done? How do you burn through $5,000 when you're only having not even 3 working days? So that's you got to find out if you're going in a situation like that, and you got to find out if the lawyer is willing to actually fight for you. Unfortunately, when it comes to federal court, you're going to have to mortgage your house in order to hire a lawyer to do that. That's the way it works, but maybe it's when you've got a situation like this, that, where it's clear cut that the prosecution is just dead wrong, that you can get it tossed out, but need more information. So, wow. Not a reason to stay the hell out in New Jersey and not take in anybody from Virginia. And speaking of, because we were finishing the show, kind of started with Virginia, I guess, with this H. Lee Townsend III. I'll see what I can find out. We'll see. Maybe I can get some more information about this guy and put him into the tyranny spotlight. But I certainly hope that T and anybody else going through a situation like that, do not let the judge operate in obscurity. Do something publicly to get his name out there. Most people have no idea who this man is, or what they just go around and they make their threats, they do these things, and nobody hears about it because so we go to city council meetings or we go to the county commissioners. Do something publicly. Let the damn insurance company know you're not going to walk away from this, and you let them know in advance. These are the facts. This is what happened to me. This is not right. This is wrong. He is committing felonies in your name against your insurance policy, which covers damages done while he is on the job. And yes, the insurance does cover the judges. The judges have absolute immunity. The insurance doesn't. And yes, I am fully aware. It's in the last minute here. The Supreme Court has ruled that judges do not have absolute, immunity for everything. If they had no jurisdiction to begin with, then they are liable for a suit. If there's so again, that's very important. If there's no evidence from the prosecution to prove jurisdiction, that they never had it, no immunity. If they had jurisdiction and they acted in excess of their jurisdiction, absolute immunity. I don't remember the citation off the top of my head. I'll try to get that in the show notes if I remember to do that. But it's better to, if we're going to try to get a judge held accountable to the courts, it's nigh on impossible, I think. But if we have any chance of doing that, we have to first bring in the insurance or the risk management or the county. We have to bring them in on a tort claim. And then if we can get past the initial motion to dismiss, then you fire off your subpoenas for them to participate at least in a deposition or in court. They call them as a witness. And you can put the judge on the stand and ask him the evidence that they based it on. Wasn't from the prosecution, I can guarantee you that. But that, then, at least if we have a deposition, we could then use that as self-authenticating evidence to show the judge never had jurisdiction to begin with and join him because he doesn't have immunity. And the prosecutor too, by the way, because there's no chance at all that there's any evidence of jurisdiction. They are not acting in excess of jurisdiction. They're acting without jurisdiction. Very important there. I covered a lot of ground here for the big show today. It was episode 76 of the big show, August 22nd, 2018. We will be live from the Fortified Compound in Mesa, Arizona this Saturday. So if we missed you today, then definitely give us a call on the Saturday broadcast. 3 more hours of Anarchy Radio. Appreciate everyone tuning in. Appreciate the continued support. And so till next time, salud.